I'm Karima Brown. It's Sunday morning and it's time for The Fix. First up, we unpack the overturning of the Seriti Commission of Inquiry's findings into the controversial arms deal with Ronnie Kasrils. He's a former intelligence minister during the Mbeki years. We also hear from the Right to Know campaign as one of the applicants to the court proceedings. Then we look back at the current Zondo Commission of Inquiry into state capture, 1 year after it came into being, and we ask the question, do commissions of inquiry get us to the truth and hold those responsible to account? And as is custom, we take a look at what's made headlines in the weekend newspapers and why. The Fix starts now. Welcome to this edition of The Fix, where every Sunday we hold decision makers to account. We tell you why it matters, how it affects you, and why you should care. South Africa's controversial arms deal and its impact on our democracy still awaits full disclosure, more so now that the Seriti Commission of Inquiry's findings were set aside by a court of law. Often described as the end of innocence of South Africa's first democratic government, the arms deal's effects still ripples powerfully in the country's body politic. Joining me in this discussion is Ronnie Kasrils, a former intelligence minister who testified at the commission. And from Cape Town, we are joined by Ghalib, Galant, who is from the Right to Know campaign. They are, of course, one of the organizations that brought the applications to have the findings set aside. Gentlemen, good morning. Thank you so very much for joining us in the studio. Mr. Kasrils, let me start with you. You testified at the commission. You were also one of the champions of getting the arms deal as opposed to spending that money on social spending like housing and so on. Now that the court has said that there was manifest failure, to quote the judge, to hold those responsible for the arms deal accountable, how do you feel about, one, your support for the deal, and two, a participation in a commission that many organizations such as Mr. Galant's have described as a whitewash?
Yes. Well, thanks, Karima. In terms of acquisition of modern weapons for an ailing defence force, which we took over, we had a defence review process which conclusion was unanimously accepted by every party in Parliament. So there is a debate about, do you buy arms, do you rather build houses, etc.
But you had two MPs, just to interrupt you.
Yes.
One cabinet minister, Trevor Manuel, famously initially said he's opposed to the arms deal. And then you had Prigs Govender, who was an ANC MP at the time. She actually resigned from Parliament after that decision. So whilst there was agreement across parties in the African National Congress and in the democratic movement, there wasn't necessarily complete agreement that this was a priority, was there?
Well, Trevor Manuel's issue was the question of funding, not that the Defence Force shouldn't be modernised. Prigs Govender, outstanding MP, and that was her decision. But I'm making the point that the review process was very extensive. There were two national ones, and there were review processes in every province, including with civil society. I would say, Karima, and I'm not trying to duck out of it, because I am a socialist. I prefer to see houses and schools and creches and clinics. But on the one hand, we do need a modern army. And that debate goes on and on. I think the crucial aspect, which the Right to Know has raised, is was there corruption, and of course many others, not just them, within Parliament, Terry Crawford Brown, all sorts of people. In relation to that, I was part of a process. I wasn't a minister, so I wasn't on the ministerial committee that dealt with this, but I did go in very positively on the debate of the need for modernisation.
We've established now that there was agreement in some quarters for the modernization of the army. The acquisition of the arms is, of course, what caused the furore, and, of course, that is where the allegations of corruption came in. And Patricia de Lille, the leader of the Good Party, who now serves in Cyril Ramaphosa's cabinet, was, of course, the famous whistleblower on this. And I remember Trevor Manuel calling her a useful idiot in one of the debates around this issue. Let me bring Mr. Galant in from the Right to Know. Mr. Galant, Mr. Kasrils has sketched the historical context of how a policy decision was made to acquire arms. But we all know that arms deals go together with corruption, not just here in South Africa, but in other places. The Seriti Commission was President Jacob Zuma's attempt, if you like, to get to the bottom of it. And many, of course, say that it was a complete farce, including yourselves. What were the key things that were missing from Seriti that didn't get us to the truth?
So one just has to read what Judge Mlambo wrote in his decision earlier last week. Essentially, Judge Seriti failed to call witnesses, failed to look at evidence that was available and that the Commission had access to. Where witnesses were called, for example, Advocate Fana Hlongwana, he was treated with kid gloves. So his statement, his witness statement, for example, addresses some issues, but when he is called before the Commission, no questions are put to him. In fact, the three justices describe the Commission as becoming supine before Advocate Fana Hlongwana. In that judgment, it says that Hlongwana received upwards of 200 million rand as fees, as brokerage fees, either himself personally or his consultancy. So there were some critical evidence that the Commission had, but chose to ignore. There were also foreign investigations that had shown how arms companies had been engaged in corrupt practices, and in fact had been taken to task in those foreign jurisdictions as well. Those also the Commission ignored.
Yeah, Mr. Galant, hold
essentially,
hold that thought. I just want to get to Mr. Kasrils on this. To go to Judge Mlambo, he says that the Commission witnesses, including Mr. Fana Hlongwane, the point that Mr. Galant was making, was treated generously, and this is in quotes. So this is from the judgment itself, by the Commission, and allowed to ramble on at the Commission with his statement requiring further investigation, particularly when it came to the 60 million allegedly paid to him. And then the point that Mr. Galant also makes is that companies such as BAE and the French company Tylers, despite evidence in their own countries that they had paid bribes, were never called. Now, you testified as a witness. You knew the terms of reference. Many people participate in processes, and they sometimes push back at the terms of references, particularly when it is designed to actually exclude evidence that can actually get us to the truth. Were these obvious to you when you decided to go before the Commission, that they're not going to call Tylers, that Mr. Fana Hlongwane was not actually going to be subjected to cross-examination, and that some documents were actually classified and remained inaccessible to the investigators?
No, as a witness, I wouldn't know that at all.
But were you comfortable with the terms of reference?
No. And the first thing which hasn't come up is that Jacob Zuma, who we know was implicated in the Sheikh issues, was not called. And right from the beginning, I was very concerned and wondering, to this day, he was the president, very easy for him to get off the hook. I would say divert attention from himself and put it all back to the executive of the Mbeki government.
So why did you go?
Oh, no. If you're called and you believe in the judiciary and you have a input that you can make, there's questions they want to ask, of course I would go along.
All right, let me turn to Mr. Galant. Mr. Galant, the terms of reference, Mr. Kasrils is saying here that he had a problem with it, but he went nonetheless. Key people were not called, such as, foreign companies, Mr. Zuma himself, who was, of course, almost subtweeted, if you like, as the young people put it today, in the entire Sheikh trial. Do you agree with Mr. Kasrils that one participates in a commission of inquiry whose terms of reference actually makes it impossible for the commission to get to the bottom of things?
Well, I'm not sure that the terms of reference made it impossible, and I particularly I think that's what the review ruling says. The Commission's terms of reference was sufficiently broad to investigate even whether things had been delivered in terms of the contract. I'll come back to that in a moment. But really to explore whether there was corrupt activities, whether people were colluding, etc. So the terms of reference are very clear. The problem is you had a commission chair who manifestly failed to exercise that particular duty. And I think that's the importance of this ruling. The first time that a commission of inquiry has been taken on review, and the justices make the point that where an institution is set up, it has to exercise that mandate legally, so it must perform its functions, and it must do so rationally. Otherwise, that's arbitrary action. In other words, it's a whitewash. So the problem isn't so much with the terms of reference, but with how the Commission dealt with the evidence.
Okay, so if one says that Judge Seriti was the head of the Commission, he obviously guides the work of his investigators, his forensic investigators. I think within the first week, Mr. Galant, one investigator already resigned, indicating that he's not happy with the fact that they are not able to access certain judgments. There's a story in the Sunday Times today that I will explain later on in that section of our program, where the journalist speaks to people who were tasked with investigating the forensic investigations, and they essentially said that the pace was set by Judge Seriti. Now, if that is to be believed, what do you think Judge Seriti's motive was to manifestly fail, as the court said, to perform his responsibilities and his duties?
So now you're asking me to speculate. It's really difficult, I think, to get into the mind of anyone. And that's why I think in this judgment, the justices were very clear that they focused on what happened, what actually happened. So the processes. I think one can take that one step further, which is to say that someone who's quite a senior judge, to have failed in fairly basic procedural requirements does point to some kind of bad intention, if you like. So without wanting to say what his motive is, there's been no proof of an instruction to whitewash the arms deal, but certainly through the behavior and making such simple procedural errors,
such as
that one has to wonder about the bona fides or mala-fides of the judge.
Mr. Kasrils, the question around the judiciary is an important one. We've seen in the state capture process that they were often the last resort or last line of defense in trying to get to the bottom of it. We're discussing the Zondo Commission in our second segment. But Judge Seriti is a judge in good standing. He has served his time, hugely respected. He says that he stands by his report. His report has been overturned because, as Mr. Galant said, they simply did not do what they were meant to do. Now, does this reflect on the credibility of Judge Seriti? Does it reflect on the credibility of the witnesses and the evidence that they have at hand? Or was this a willful attempt to just sidestep what was in front of them?
Well, you know, like our friend in Cape Town has said, it's to speculate is dangerous and difficult and so on. What has occurred is that confidence in the process and in a judge such as Seriti is undermined, and confidence in the right to know in civil society is strengthened. This is a very good thing that has come out. So it's impossible, as our friend has said, to get into Seriti's mind.
But if you talk about commissions of inquiry, many people like Corruption Watch and Right to Know often remind us that it's not a replacement for actual criminal investigation or even civil action against people. And we only saw one criminal action proceeding, and that is, of course, Shabir Sheikh. No one else was prosecuted in relation to the arms deal, and that was largely because under President Mbeki's regime, where you served, it was found that in the primary contracts everything was okay. Clearly here, evidence has not been tested or been cross-examined. Do you still stand, as someone who served in the Mbeki administration, do you still stand by the assertion that there was no corruption in the arms deal?
At the level of the executive, to this day, and of course this is where these processes are important, I must say that I can't come out and say there was corruption there. I genuinely had not seen it. As I say, I wasn't on the ministerial committee, but of course I was close to everything. And I can't see that. That doesn't obviate the fact that the Right to Know, Corruption Watch, given all the bad odor around this and foreign companies, etc., that this doesn't obviate that there might not have been. This is where a commission of inquiry and the judiciary process needs to serve to open this thing up, and that hasn't come out from the Seriti Commission, unfortunately.
And more importantly, a court found that he had, generally acted in bad faith, if you like, and had deliberately not done his work. So having said all that, I'm talking about Judge Seriti.
Oh, I see, yes.
So given the fact that the Seriti Commission was so severely criticized in the judgment, the findings were overturned. We have President Jacob Zuma that is actually in court now on corruption charges relating to the arms deal. Would you still unequivocally say that the arms deal was not corrupt?
Oh, there was certainly corrupt aspects. We've seen this, both in terms of the foreign players and in terms of the secondary offset, where Shabir Sheikh, Jacob Zuma came in. The question that I really cannot comment on, and I must say to this day, I still do not see evidence of corruption at the level of the Ministerial Committee.
Mr. Galant, do you share Mr. Kasrils' view?
I would have to say, of course, no. And I would want to remind us that the findings haven't been overturned, they've been set aside. It's as if the committee's report or the Commission's report doesn't exist. But what does exist is something like 2 or 3 million pieces of evidence in a warehouse, in a container, that's currently in the possession of the NPA. So actually what needs to happen is that the NPA needs to trawl through all of that evidence. It needs to satisfy itself whether there's sufficient evidence there for a criminal case, whether they have a winnable case in the language of Bulelani Ngcuka, or if there can be civil prosecution as well.
So it brings
For
me to
example, we have the... So just to say that we're still paying for the arms deal. So some of the contracts only conclude in 2022. One of the terms of reference of the Commission was to look into those contracts, and if there was any corrupt activity there, to set them aside. So that's one option still open to us, I would want to say.
Okay, we're running out of time, gentlemen. Mr. Kasrils, Mr. Galant takes a different view from you, saying that it doesn't look as if the primary contracts also went through the process. And he makes an important point. He says that the findings have been set aside, so it's as if Seriti never happened. So all the questions that were there before Seriti still need answering. And like I said, we've had one person go to jail, did not serve his full sentence, and of course everyone else walking around free, including former President Jacob Zuma. We now have the Zondo Commission of Inquiry. It's 1 year old. We're going to be looking at its successes, if there are any. Given the fact that it cost, I think, 140 million to set this commission up, the Seriti Commission, I think the Zondo Commission is already at 100 million. We've got 10 million unemployed people. Our economy is fast tanking. It's not doing well. Ordinary people will ask you a very simple question. These commissions, if we found, like in the Seriti one, is actually a whitewash. 140 million down the drain. We're still paying for the arms deal contracts that are maturing in 2020. Is this the best route to get to the truth, to hold accountable those who have done wrong? Or should we just not get the police to do it? Is commissions of inquiry just not a way of, putting a Band-Aid on cancer?
Yeah. It's Terry Crawford Brown, very well said. It's a way of parking a hot potato. And commissions of inquiry, beloved by the British Empire, there's been so much satirical operators written about these commission of inquiries. A government wants to put aside something that's inconvenient, Marikana shootings, etc. So there is that particular problem. And I'm not saying in one fell swoop, away with them. We are a democracy in its infancy. And if we had commissions of inquiry that didn't go on and on, that spent money well, that came to the nub of it quickly, we might see better results. I, for one, would rather see the straight criminalisation, the legal process, going for the jugular. That would be the best way as far as I'm concerned.
Mr. Galant, we're running out of time. I'd like to give you a final comment on whether commissions of inquiry is just a waste of taxpayers' money and whether the criminal justice system shouldn't just take its natural course.
So I think we must be cautious because we've also just come out of 7 or longer years of hollowing out of our criminal justice system and the prosecution authority. Commissions of inquiry are there to highlight evidence, to unearth evidence, if you like, and then to make recommendations. That's their power, and it's a really important function that we have. It's the first step. What we haven't seen is the prosecution, is a few choice people wearing orange overalls. So we've had, and particularly in this one, Judge Zondo is sitting with a much bigger problem at the moment. All the state-owned enterprises have been hollowed out. I think if the NPA went through the evidence and made some strategic prosecutions, and those resulted in incarceration, we would be more confident in this overall process.
All right,
One
Mr. Galant,
last thing just to say is that with the setting aside of this, that Jacob Zuma can't rely on the report any longer for a stay of prosecution.
All right. Thank you, Mr. Galant, Mr. Kasrils. We've, of course, got lots to talk about. Some of these will be overlapping into our next conversation, which is, of course, after the break when we take you back a year into the current Zondo Commission of Inquiry into state capture. Stay tuned.